Hello, everyone. Good afternoon and welcome to this week's Business in 2021 webinar presentation. My name is Kathy Purdy and I'm the Marketing Manager here at Bond. I'd just like to go over two quick housekeeping items before we get started. Please enter your questions using the Q&A box located at the bottom of your screen, and we will do our best to answer those as time allows throughout the program. Once the webinar has ended, if you would take a moment to complete the survey, we would appreciate it. Your comments and suggestions are important to our panelists and also provide us with topics for future presentations. So it's now my pleasure to introduce today's moderator, Andy Beaubrock.
Kathy, thank you. Good to be with you. Good to be with everyone on today's webinar. We have another great panel today covering a number of emerging topics that we think you'll find of interest. I know a number of you have been very helpful in providing recommendations for topics for our future programs. They've lightened up a little bit, and more are welcome. So we'd certainly appreciate you. If you have topics, things you'd like us to cover, let us know. You can email us, you can email our marketing department, you can just note it in the chat or comment features. We take a look at them every week and digest that information. Again, keep your questions firing away. As you know, I do my best to answer as many as I can, along with my colleagues and panelists here to do the same. We can't get to all of them, certainly, but again, we do our best and keep them coming, as I say. So before I turn it over to far more interesting and insightful people than me, I did want to cover a couple subjects here. The first being the HERO Act. I think we're still at the point where we can't have, unfortunately, a session go by without touching base on this. And I know that there are many questions out there still, so I'm trying to anticipate some of those and provide some guidance to you. At the end of last week, of course, the end of the month came and went, and we didn't have any action from the State Department of Health with respect to the designation. For those of you who may remember going back to September 6th, the designation that triggered all of us to get our HERO Act plans off the shelf and implemented just ran until the end of the month. And as you'll see on the next slide, the state has, sorry, if we can move it on to the next one too. Let's go, next one. Great, thank you. So the state has extended the designation that then triggers the HERO Act implementation and are having our plans in place until the end of October. Not sure why there was a delay there. We figured that would be extended based on circumstances and everything we understood, and indeed it was. So for the time being, we need to continue to have our HERO Act plans in place. I think the state will reevaluate whether or not to extend it further at the end of the month, or hopefully before the end of the month as we get closer to the month, and we'll keep our ear to the rail on that issue and report back too. So moving on, Kath, can you advance? Thanks. So I want to drill down a little bit. We got a lot of questions on changes that were made to the model plans. And this raised a number of questions in clients' minds and in friends of the firm's minds who attend these webinar programs. I wanted to drill down a little bit. Really, it fell into two big categories: one, face coverings, and two, physical distancing. And just so we're clear, we want to delineate what those changes were from the model plan that was published way back when this summer. We'll call that model plan 1, and then these updated plans, which we're going to call model plan 2. So on the following slide, you'll see the changes to the face coverings or masking. Right, so we had a generally applicable widespread requirement of face coverings in Model Plan 1, which you were all familiar with, and if you adopted the model plan was included, and likely if you created your own, did something very similar in there too. Model Plan 2 created a distinction in one sense, reverted as a default back to the statutory language that, hey, if the plan is implemented and triggered, your masking requirements need to conform with whatever state and federal guidance that's out there. And of course, New York has adopted the CDC's guidance on masking, which continues to change and requires monitoring. But all that's accessible and content that you can digest and implement with relative ease. Not to say it won't have an impact. Certainly it will, but it's out there, right? And you can find it and you can adhere to it. However, the model plan 2.0 created a distinction for those workplaces where everyone is vaccinated, and not necessarily just employees, but everybody is vaccinated. In which case, masks can be optional. They're recommended, but not necessarily required, consistent with whatever state and federal guidance is out there. So again, that distinction could be relevant to you. One question that has come up with some frequency is, well, do we have to change our plan? Can we just continue to follow our uniform masking requirement that was in our original plan? I think the answer there is yes. I think if you have a stricter term in your particular model plan that you've elected to implement, I think there's no prohibition on doing so, and you could keep that particular requirement in place, notwithstanding this ability, if you have a fully vaccinated workplace, to be a little more liberal with the masking requirements and moving into a recommendation. On the second front is the physical distancing, and there we saw some distinction again being made in the second version, and then it has to be done to the extent feasible, and then in conformity with state and federal guidance that may be out there. And again, that's consistent with the statutory language. So the questions that I think were at the forefront of most people's minds with these changes was, okay, well, at this point, we've adopted a plan or a model plan. I'm guessing a model plan in most instances. We have conducted a verbal review of that plan with our employees and the others who may be covered under the statute. And we've published this. We've posted it on our bulletin board. We've have it on our intranet or other electronic means, and we have it in our employee handbook. And now there's a change. Do we have to likewise go through this process all over again? Do we need to modify our employee handbook? If we want to incorporate this change, we have to modify our employee handbook, republish that, disseminate that to employees. Do we need to conduct a further verbal review? All excellent questions. We've looked at this issue closely over the past week, and I can tell you that neither the statute nor any of the guidance that the state has put out on the HERO Act addresses this specific issue. Certainly, there are very particular timing requirements in place when it comes to adoption of the model plan and the verbal review of the model plan. And those specific requirements don't contemplate changes being made to the underlying guidance or model plan. Further, an argument can be made that there is no requirement in the statute that you adopt a new plan and that you disseminate a new plan to employees and that in your handbook, for example, and that you conduct a verbal review. But I want to caution you, right? This is an issue that you're going to want to examine with your attorney to review carefully and make sure that you're comfortable with. And also, it could depend on the particular facts and circumstances at your workplace, how it's structured, what the risks of exposure are. These are all factors that I think you're going to want to take into consideration, giving the lack of any clear authority on what to do in this situation. This is not, again, an uncommon situation where we have to fill in the gaps when it comes to compliance. Frankly, we've done this all along throughout COVID, and this is another example of where working together, we can craft a solution and one that ultimately I think you can be comfortable with at the end of the day. But that's going to vary depending on your business and your risk tolerance and comfort. All right, so hopefully I addressed that issue. Just one caveat there, or two caveats, I would say. Let's say you're going to make a change to your plan. In putting aside this issue of the verbal review and whether you need to republish and redisseminate your entire employee handbook with this updated plan. And again, I think there's a basis to say that you don't need to do that, but you're going to want to review that individually. It still could make very good practical sense, one, for you to incorporate those changes nevertheless into your plan, and to make sure that your updated plan reflects those changes on your intranet, on your bulletin board, or however else you're disseminating that information and making it available to employees. Second, to the extent you're going to incorporate a change, and maybe it's a different change in the future, that you'll want to, if you're not going to conduct that verbal review and republish your employee handbook, for example, you're going to want to communicate with them and your employees about what those changes are and explain those changes. I think that just makes good practical sense. Finally, as the second caveat, I think we're likely going to see more changes to these model plans. I doubt this is it. I think it's reasonable to expect there'll be more changes, which I think goes to, let's try to find a practical approach that makes good sense for your business organization. But conceivably, there could be a very significant change that could come up with respect to the model plans and what the state is saying is now required under the HERO Act. That could be reason to reevaluate this question of, all right, do we need to conduct a verbal review? Is this change significant enough so that we want to err on the side of caution and disseminate, again, an updated version of the policy clearly rather than just making it available? But those are issues you're going to want to, again, work with your legal counsel on and make sure you get to a place that you're comfortable with. All right, finally on the HERO Act, the state updated its FAQs. I would say here there wasn't a lot of substance that is really noteworthy. There is now these FAQs available in a number of different languages, as well as the model form and the model plan and the standard are now also available in Spanish. I don't know if we've covered that yet. That's relevant because if we have an employee as part of our verbal review and training and dissemination, if we have an employee whose primary language is Spanish, we now need to provide that information to them in that language. Otherwise, if somebody's primary language is not English or Spanish, we can use the English language forms to comply. Some references to Part 2 of the HERO Act, what I call is Part 2, and that's our obligation as employers, certain sized employers with 10 or more employees, to create workplace safety committees. Some reference to that in these FAQs, and that there'll be some forthcoming guidance on this. Again, we'll be reporting back on that issue. Keeping in mind November 1st isn't that far away. I expect we'll have an update and review of Part 2 of the HERO Act and these workplace safety committees on next week's webinar. I think that about covers it for the HERO Act. I did just want to briefly mention a few issues on New York State COVID leave. As a reminder that you'll see on the next slide, the FFCRA expired at the end of the month. Again, I'm still not hearing any updates or new information on that legislation, that federal legislation being extended. So it's since come and gone. But keep in mind, and obviously that extended FFCRA covered a wide array of potential COVID-related leave circumstances, including as a category, situations where an employee tests positive and is subject to a governmental quarantine order, has to stay at home, that the FFCRA benefits would apply in that situation. I mentioned that scenario, of course, because we are still seeing increased incidents of COVID and positive tests of employees, and consequently, local health authorities are issuing governmental quarantine orders. And that's important to note because we still do have New York's COVID sick leave that was enacted way back in March of 2020. That's still on the books. There's no sunset provision in that particular legislation. And so if you have an employee who is subject to a governmental quarantine or isolation order, those benefits are available to them. And again, keep in mind a few things. I'll touch on in a second, but New York State and the State Department of Labor back in January this year issued some very expansive guidance and arguably so expansive it exceeds the scope of what the statute, the underlying statute, required on the part of employers to provide this benefit. But that guidance is out there and should be considered. Again, I'll mention it a bit more in just a second. Also keep in mind, if an employee is asymptomatic and is able to work remotely, even though they're subject to a governmental quarantine or isolation order, they're not eligible for this COVID sick leave benefit. So it's not just that you're quarantined and automatically you have this benefit. Again, if they're asymptomatic and can work remotely, then they can do so and they're not eligible for this benefit. For smaller employers, and you'll see on the next slide, I have the different eligibility criteria and types of leave. For smaller employers, PFL or DBL might apply in a particular circumstance. And you see in front of you, again, it depends on your size, the amount of revenue that your company has. Hopefully this is familiar to some of you, but we wanted to provide this slide just so you have this data. It's still available on the state's website. I'll shoot a link in the chat function to where you can access this after my portion of the presentation is done. So you have it. But again, there you have the particulars on what needs to be provided under the law. And again, for smaller sized employers, PFL or DBL and your respective insurance carriers will be involved in that process. And finally, just keep in mind, there are no tax credits. Unlike the FFCRA, there are no tax credits for employers' compliance with the COVID sick leave benefit that's coming out of your pocket. You can't use PSL or some other bank of time to satisfy that requirement. It's a separate bank of time provided to eligible employees. I mentioned some guidance too, as you'll see on the next slide. This guidance addressed, I think, some of the compliance questions or gaps that arose from the actual legislation going back to March of 2020. One of those questions is this benefit available just once to an employee? In other words, I'm subject to one governmental quarantine order. I get my up to 14 days and that's it. What if I test positive again? And of course, these were things that, frankly, I don't think anyone thought of back in March of 2020. At that time, many people were thinking this would be over in 2 weeks' time. Of course, that's not the case. We are seeing repeat positive cases and repeat quarantine orders being issued. What I would say to you is this, and I'll push a link out to this guidance as well. This guidance contemplates employees potentially being eligible for the state COVID sick leave benefit up to 3 times. For the second and third time, they would need to test positive, right? In other words, they couldn't be subject to a quarantine order just based on their exposure to someone in their household who tests positive, for example. They actually have to test positive. But there's a question over the state's reach here and their interpretation of the legislation. I'd say that's especially true in the guidance when it comes to an employee who is sent home due to concerns about potential exposure. In that situation, the state has said in this guidance that they nevertheless need to be provided with the state COVID-19 sick leave benefit, even though there isn't a governmental quarantine or isolation order in place. Again, that stands in stark contrast with the statutory text and the underlying legislation that created this benefit in the first place, which very clearly contemplated there being a quarantine or isolation order in place. So if you have these circumstances arise, I encourage you to take a careful look at this guidance, particularly where you're sending somebody home because of concern about exposure, or you have successive needs for COVID leave, that you examine this guidance closely, contact your bond attorney, and just walk through the process that you intend to follow so that you understand the compliance requirements and potential risks that are out there, and you find a plan that makes good sense for your business or organization. All righty, so that's what I had for you today. I'll take a peek at your questions here. Again, I'll push out those 2 pieces of guidance and the links to the state guidance on the issues we talked about. But without further ado, I'm sure you'll be far more interested to hear from Teresa Rusnak than from me. Teresa, as you know, is a labor and employment attorney who works in our Rochester office, somebody I work with very closely, and was thrilled that she wanted to come and speak with you today. Teresa is going to cover some recent guidance. There's so much that comes out. I think that's one of the great things here. We've got so many different people trying to keep track of all these different things. And I was thrilled that Teresa kept an eye on this HHS issue, because there's so much concern, and appropriately so, when it comes to confidentiality and our employees' health records. And Teresa wanted to share some insights that she found through HHS. So Teresa, great to have you.
Okay, thank you, Andy, and hello, everyone. So as Andy mentioned, I'm going to be discussing the guidance from the Department of Health and Human Services on Hipaa. Specifically, the guidance is entitled Hipaa, COVID-19 Vaccination and the Workplace. So right from the get-go, you know it's going to be good guidance for employers. It was published, like I mentioned, by HHS on September 30th, so just a couple of days ago. And it essentially uses an FAQ format or a Q&A format to address long-standing questions regarding Hipaa and an employer's ability to inquire about vaccination status with regards to that law. And I know that's something that I've gotten a number of questions about. Frankly, I got questions about it yesterday. And I know employees continue to assert objections to giving employers this information. And when they do, they usually say, I don't want to give you this information. It's my protected medical information. It's a violation of HIPAA. And I think while I and other attorneys at the firm have been dispelling that myth, that that's not actually what HIPAA covers or what it says, having this guidance directly from HHS is going to do that much more to really drive home to employees that no, you're not asking them to break the law, and you yourselves are not breaking the law, at least as it pertains to HIPAA and COVID-19 vaccination information. So next slide, please, Kath. So the guidance definitively states, frankly, in several places, that the HIPAA privacy rule, which is really the part of HIPAA that we're concerned about, does not prevent businesses or individuals from asking whether their customers or clients have received the COVID-19 vaccine. The privacy rule also does not apply when an individual is asked about their vaccination status by a school, employer, store, restaurant, entertainment value, or another individual. Or when an individual asks another individual, their doctor or service provider, whether they are vaccinated, or when an individual asks a company, such as a home health agency, whether its workforce members are vaccinated. So this is pretty broad, right? I mean, reading this gives employers and companies and frankly venues the ability to ask customers and clients if they've received the COVID-19 vaccine. And I think that could be integral for a lot of employers and businesses on this call. It pretty much backs up that businesses have the right to ask about vaccination schedule, and they're not going to run into a HIPAA problem. So I was pleased to see that stated as broadly and as clearly as it was. So remember, at this point, it extends to customers and clients. You can also ask a company, and they give the example of a home health agency, whether its workforce members are vaccinated, either before you engage them or before you do business with them in some other way. So those are all proper questions, and they're not going to be questions that the HIPAA privacy rule is going to be implicated by. Next slide, please. The privacy rule also does not prevent any individual from disclosing whether that individual has been vaccinated against COVID-19 or any other disease. It really does not apply to individuals' disclosures about their own health information. That makes sense, right? Individuals are free to disclose their own vaccination status to anyone at any time as far as HIPAA is concerned. It's not a HIPAA violation to disclose your own vaccination status to anyone that you should choose to disclose it to. So that was another important point made by the guidance. Next slide, please. And then I know the question that most people have been wondering about, and I've quoted it here: does the HIPAA privacy rule prohibit an employer from requiring a workforce member to disclose whether or not they've received a COVID-19 vaccine to the employer, clients, or other parties? And the answer, and this is, I did not bold this, HHS actually bolded this, and the answer is no. The privacy rule does not apply to employment records, including employment records held by covered entities or business associates in their capacity as employers. And again, that's the position that we at Bond had been advocating for the past several months, or really, frankly, the past year and a half, but it's good to see that here in writing definitively from HHS. So no, the privacy rule does not apply to employment records, including employment records held by covered entities, which are those subject to HIPAA, or business associates, which are those that exchange HIPAA covered information with covered entities in their capacity as employers. And the FAQ goes on to state, generally, the privacy rule does not regulate what information can be requested from employees as part of the terms and conditions of employment that an employer may impose on its workforce. So I think that's about as clear as can be with regards to HIPAA. You absolutely can require your employees to disclose whether or not they have received a COVID-19 vaccination. It is not going to implement or not going to implicate the HIPAA privacy rule. Next slide, please, Steph. Additionally, the privacy rule does not prohibit a covered entity or business associate from requiring or requesting that employees provide documentation of their COVID-19 or even though this is a COVID-19 guidance, the FAQs add flu vaccination to their current or prospective employer. So a covered entity, a business associate, an employer can require that there's documentation of the COVID-19 or flu vaccination from their current employees, from their applicants or prospective employees, and not run afoul of the HIPAA privacy law. And furthermore, the privacy rule does not prohibit a covered entity or business associate from requiring or requesting that employees sign a HIPAA authorization for a covered healthcare provider to disclose the workforce members' COVID-19 or varicella vaccination record to their employer. So you can require the provision of documentation, you can require the signature of a HIPAA authorization. Those are things that can be required according to this HHS guidance. Next slide, please. Additionally, and I know this, believe it or not, has been one that I never thought implicated HIPAA in the first place, but I've been hearing from enough clients, and frankly, HHS must be as well, because they decided to include it, but they explicitly state that the privacy rule does not prohibit a covered entity or business associate from requiring or requesting that employees wear a mask while in the employee's facility, on the employer's property, or in the normal course of performing their duties at another location. So I have heard of some employees objecting to wearing a mask, saying that it's connected to their private health information and that it's a HIPAA violation. That is not correct per this guidance and per our general understanding of HIPAA. But as you'll see, this guidance explicitly states you can require your employees to wear a mask while on your property or in the normal course of performing their duties at another location. And certainly that's not going to run afoul of HIPAA. And finally, the privacy rule does not prohibit a covered entity from or a business associate from requiring or requesting that employees disclose whether they have received the COVID-19 vaccine in response to queries from current or prospective patients. So if you are a covered entity and you're facing that question with regards to your patients, HIPAA is not going to prohibit the covered entity from requiring that disclosure on behalf of the employees. Next slide, please. There is a little bit of language about documentation concerns in the HHS guidance. The guidance mentions that documentation or confirmation of the vaccination must be kept confidential and stored separately from the employee's personnel files under Title I of the American with Disabilities Act. We know that all medical information, and this explicitly includes vaccination information, needs to be stored separately in a confidential file that is different and distinct from the employee's personnel file. So that's something everyone should have already been doing, and this just confirms that the vaccination information needs to be added to that confidential medical file as well. And then generally, the guidance makes a statement that the privacy rule regulates how and when a covered entity or its business associate may use or disclose information about an individual's vaccination status. And generally speaking, individual authorization is required for the disclosure or use of that information, but it is not implicated by simply asking your employees or requiring them to tell you if they are vaccinated or not. This would more come into play if you wanted to disclose that information to someone else outside of the company, I think, in that case. Next slide. Yeah, and this is my final slide. So I didn't go into this because I know not everybody here is a covered entity And I know not everybody fits into these categories, but if you are on this list here in the first bullet point, or you employ people that are, I strongly urge you to check out the full guidance. There is specific information in the guidance on when disclosures can be made by hospitals, pharmacies, health plans, physicians, nurse practitioners, and clinicians, even without patient authorization for or without a patient HIPAA release. So again, if you fall into those categories, I encourage you to check out the guidance. There is specific information pertaining to you all and that issue in the guidance. The full guidance for everyone else that's interested can be found at that link. And I encourage you all to check it out. Use it with your employees, use it with your supervisors. Let it be a tool that helps you explain why you're asking for the vaccination information that you're asking for and why that it is not a HIPAA privacy rule violation. So with that, I'm going to turn it back to Andy.
Teresa, thank you. That's very helpful. I again, like you, I've had that question posed by clients who are having employees cite to the privacy rule in HIPAA as a basis for not disclosing the information. This is, I think, helpful information that our client contacts and friends of the firm can use to correct any misunderstandings about that issue. And I was glad to see too that HHS did point out the distinction that exists, or the countervailing law that exists with respect to the ADA and the employer's obligation to maintain the confidentiality of that information or records they may receive with respect to vaccination. And I guess too, although the EEOC has provided what I think is pretty considerable leeway for employers to inquire about vaccination status. Again, it's something you're want to do carefully and thoughtfully, and hopefully the assurances that you can provide to employees that the information will be safeguarded will facilitate better compliance to the extent you're having an issue. So Teresa, thanks. Hope to see you back here sometime soon. All right, back from some time off. Katie, you weren't here. I co-opted your slide, the New York Times slide last week. Reviews I got were, vastly disappointed that I was there covering this information instead of you, all of which I took to heart. But I've kind of, pulled myself together for this presentation, and very relieved you're back.
Yeah, that's right. Well, my hair has a little bit more volume than yours, so that's what they were missing.
That could be. Well, I was feeling better, but now, no, not as much. Yeah, thanks. All right, take it away.
All right, here we go. The good news that we are seeing in New York is that we have seen a consistent decline in cases over the past 14 days. The numbers of the cases have been fluctuating, as you can see in this graph. Yesterday, I looked at the website. The rate of change over the past 20 days has been minus 20%. And then today, you take a look at the rate of change, and it's actually a 7% decrease in the amount of cases, which is still good news. I'll take it. We've seen, again, you're seeing hospitalizations going down. Deaths have remained consistent, but that case number thing, the more that this decreases, the more that those case numbers go down, the more likely we are to see a few things change. One of those things potentially, if cases go down enough by the end of the month, I think that there's a good chance we won't see the HERO Act renewed. But again, really depends on where we get these case numbers down to. Is this going to be a steep fall, or is this going to be a slow decline? If it's a slow decline, it's more likely, I think, that we will see the HERO Act, for example, be reinstated again. But on the other hand, if we see a steep decline, I think that we're heading in the right directions for the holiday season, which is gearing right up. So looking at vaccination progress, again, we've seen just, I've been gone for 2 weeks, but we've seen at least a 1% increase in all of these numbers since 2 weeks ago. I like to see that, we are at, for 12 and older, 75% of people are fully vaccinated. there has been, last week we did see a number of people receive their first shot for the first time as a result of the vaccination mandate that went into effect for healthcare, certain healthcare providers. I'll use that because I will be talking about that right now. A few updates for vaccine mandates. Looking at New York City schools, that vaccine mandate went into place. 95% of the Department of Education employees are vaccinated in New York City. It's like 99% of principals and 96% of teachers in New York City are all vaccinated. The remainder have been placed on unpaid leave. New York courts has its own vaccine mandate. Interestingly enough, there's only one judge that has not, the only judge that hasn't received an exemption, just didn't get the shot. And that judge sits on the Court of Appeals. That is a big deal to have a Court of Appeals judge. That is the highest court in New York State. They are doing arguments where this judge now has to be video conferenced in to listen to arguments. She is the only one in this entire court system that did not get an exemption, just didn't get the shot. Okay, looking at healthcare facilities, October 7th is the due date for everyone else who is not a hospital, who falls under, or a nursing home that falls under the emergency regulations that came out from the Department of Health. That includes the Article 36 facilities. That's one of the example of those is a home care, home health care service agency. But what will be interesting is the arguments for the case regarding with the TRO. Those are coming right up. So the decision will be coming out soon about this case and what's going to happen with the temporary restraining order that's currently keeping the Department of Health from enforcing the lack of a religious exemption. That was a lot of words that I had to try to fit into a sentence really precisely because I didn't want to get it wrong. All right, so as a result of the vaccine mandate for healthcare providers last Tuesday morning, I believe this came out. The governor issued executive order number 4. Remember when we got into the hundreds? Well, we're at 4 now because we have a new governor and a new state of emergency. This state of emergency relates to the staffing crisis. It doesn't say it relates to COVID-19. It's just the staffing crisis itself. And generally speaking, with executive orders, governors in New York State have the power to suspend or modify laws with an executive order. But what was different about the COVID executive orders was that the governor had the power to issue directives to say, you have to wear a mask in a public place. Okay, so this executive order has a bunch of suspensions that occurred that are aimed to help boost New York staffing rates at hospitals and places that are being impacted by the vaccine mandate. It allows, again, this was in place during the prior state of emergency, but out of state or out of country physicians, nurses, nurse practitioners, physicians assistants, and more to come in and practice in New York State without having a New York State license. There's also additional rules for and allowances for medical students to come and join sooner than they normally would. I took the easy route out in terms of a doctorate and went to law school for 3 years, so I don't know what happens at med school. But otherwise, that sounds like a good way to get more people involved. Additionally, it expands what labs can be testing for, so that is supposed to help. It also allows nurses to do certain things without physician supervision, so long as they have the correct credentials in place to do that. So this executive order, we're still seeing how it's impacting the healthcare systems in New York. A major issue is that there's fierce competition right now for healthcare practitioners everywhere, not just in New York, but the entire United States. Every other country is also competing for healthcare providers. So, how this will be used will really be, we'll see what's going to happen. It will really matter on certain incentives. But at least now we do have the ability to bring these people in. All right, so this is another one that came up, this Department of Labor Unemployment Insurance FAQ. This came up in the past week. This is about directly impacts the vaccine mandate that came out for healthcare providers. This is what I've been talking about for the past few minutes. I am not sure if this was discussed last week, but for the purposes of the emergency regulation, if they are refusing to receive the vaccine, they do not qualify for unemployment insurance. That's my very brief overview of it. If you have questions about that, a host of labor attorneys who are on this call that you can ask for more details, or I can put you in touch with them. There was another major announcement that came out this week about the Department of Health. I believe right before I went on vacation, it's always pre-vacation and post-vacation, BCAD, that the commissioner of the Department of Health, the current one, Howard Zucker, had tendered his letter of resignation saying that he would step down once a new commissioner came into place. The governor has tapped Mary T. Bassett as the next Department of Health commissioner. Her term would begin on December 1st, but she still has to be confirmed by the state Senate. She was previously New York City's health commissioner from 2014 to 2018. She worked with regarding the Ebola response and the 2015 Legionnaire's disease outbreak. An interesting fact about that time was that the state, at the behest of the prior governor, had been trying to wrest control away from the New York City Health Department to deal with the Legionnaire's outbreak. So she had a lot of back and forth between the health commissioner at the time, who was Howard Zucker, and the governor, and really went up to, it was pretty brutal for a bit there, what was happening with that. But now we are in a different disease outbreak. She currently is at Harvard and will be quitting that position. So she will be coming in December. I figured that was worthwhile to bring to all of you, since I know this has been on the news, and worth at least giving a brief overview of who she is. Finally, we saw a minimum wage increase come into place last week for upstate and for Long Island and Westchester. The Long Island and Westchester one had been announced previously to go to $15. But in upstate New York, generally, I know it's a broad area, so Western New York, everyone, it's $13.20 is the increase in minimum wage. And I believe that's my last slide. So with 2 minutes to go, I'm going to kick it back to Andy.
All righty, Katie, thank you very much for that overview. I appreciate it. Good to have you. Good to have everyone else with us. We'll be back next week. Please tune in. Here's our contact information if you need to get a hold of us. In the meantime, be safe and be well. Thank you.